So what I thought I'd do today is begin the next step in the process from my thought perspective, and to go through in a workmanlike fashion the actual substance of the rules dealing with evidence going all the way back to the beginning. What should happen as we talk about these is that you go, oh, so that's what that meant. Because in all likelihood, the first time that we talked about it, you really weren't sure what the heck I was talking about, or you maybe got a third of it. And I think you're going to be surprised, hopefully pleasantly surprised, by how much you actually know now that you did not realize that you know. And the way I'm going to do it is I'm going to go through the ebook. I'm going to go through the rules in the ebook. So if you have your ebook with you, or you have your hard copy of your book, or if you happen to have it on your computer, it should be relatively easy for you to see the things that I think are important. And the first one, of course, I've got right up here on the wall to point out anything for you up here. Electronically stored information is the equivalent of written material, right? So written material means anything that was produced that's the equivalent of writing. So if I type an email and it's not printed out and it's stored on a server, it's still electronically stored information. Just want to sort of point that out to you. The rest of these are just definitions. It tells us where the law works. There's not much there from the standpoint of substantive test type questions. I hope you all realize now that ascertaining the truth and securing a just determination can actually be counterintuitive things, in that one doesn't always flow into the other, right? The process of the application of evidentiary law to trial guarantees that the factual truth will not at some level be admissible to the court. Because for policy reasons, we've made a determination that the factual truth will have an improper impact on the finder of fact in the case. And an awful lot of evidentiary law is built around the premise that people don't need to know certain things, because if they know those things, they will no longer rationally make decisions. And what's interesting about that is all these rules were created without any real concept of how human psychology works, even if you accept that maybe we have some idea of how it works now. You may be in the category of thinking that it's all hokum science and that we don't really know. I kind of fall somewhere in between the two. Sometimes I think we actually know something, and sometimes I think we have no idea at all. But I just want to point it out to you that how does the famous comedian Richard Pryor describe it? There is no justice, there is just us. And I think Richard probably had that right. So, rulings on evidence, Rule 103. This is the first real rule that we started to look at. And as we go back and look at Rule 103 now, we realize a couple things. The first thing we realize is that 103 places the burden on the litigants, the parties and their attorneys, to raise evidentiary issues at trial. And that if the evidentiary issues are not raised at trial, they are waived, unless they create a constitutional error that results in real harm to the litigant in the case. And that's almost only a criminal defendant, and it's very rarely that occurs. So as we look at the rule, I've got to show that the ruling affects a substantial right, and I made an objection or moved to strike when it was something that admitted evidence, and if it excludes evidence, I inform the court of the substance, and offer of proof, And we talked about at length how an offer of proof is the gold standard as the attorney. So that when I try to admit evidence, the court excludes it, I would say, Your Honor, may I make an offer of proof? And the judge should say, Counsel, you can make an offer of proof. They can't prevent you. But for your ruling excluding this evidence, the following would have occurred. Witness A would have been called. They would have said X, Y, and Z. This is relevant for the following reasons. Why is the offer of proof so important? Well, we now know that the offer of proof is the last-ditch effort to make the argument to the judge to potentially get them to change their mind. And it's also the signal to the court at the appellate level that it's your belief that there is a right of your client that is being harmed by the ruling of the judge. Now, why is 103's actions and interactions so important? Because most evidentiary mistakes by the judge are ruled on an abuse of discretion standard. And abusing judicial discretion is another way of saying, hey, it's not going to be an issue. It means the judge can screw up significantly when dealing with evidentiary rulings, and it's not going to have a negative impact on the appellate strength of the case. That's why they place the burden on counsel through 103 to make objections. And not only do you have to make an objection, but it has to be in a timely objection. It has to be a timely motion to strike. And if it's an exclusion, it has to be an offer of proof. Now, they give us the caveat in the rule, unless the substance was apparent from the context. But to make the argument that the substance was apparent from the context is placing a trial decision in the hand of appellate judges and appellate lawyers, many of whom have never been within the arena of trial. So you're asking someone who doesn't understand the world in which you operate to take the same read on the case that you would have taken. And I'll give you a classic example. Young man, First Lieutenant Ranger in Iraq, pulls up an individual who is a suspected terrorist sympathizer. Brings a suspected terrorist sympathizer in. They do a little intel gathering on him, and then he's tasked to take the sympathizer back to his village. Something happens in a culvert in the middle of the sandstorm, and the sympathizer dies with a 9mm bullet in his head. Lieutenant's position is that I was trying to get additional information out of this guy, and he made a lunge for my gun, and we struggled, and the gun went off, and he died. Prosecution's position is that the lieutenant took him to the culvert and executed him because he'd lost 2 soldiers in that village the week before. At trial, a blood spatter expert testifies for the prosecution, saying that the way the blood was spattered in the culvert was indicative of an execution and not a struggle. You know, where the splatter is in the culvert, the angles, all these things are testified as it's a government expert witness. The expert witness then sits and watches the rest of the trial. The defense expert witness testifies and gives a completely different interpretation of the splatter based upon some additional information that the government expert did not have available. The government expert comes up to the defense attorney on the break and says, if I had known what your expert knew, it would have changed my testimony. The defense counsel had previously tried to exclude the expert testimony of that expert at trial and had lost on that motion with the judge. Should he raise to the judge the statement that's just been made by the government expert? Should he recall the government expert now during his case in chief and put him on the stand? Would you agree with me that that might be a case dispositive decision? The defense counsel makes the decision not to call the expert and to simply let it be a battle of the experts because he thought the panel was tired of listening to the evidence, that he'd made his case so strongly it wasn't necessary. The government expert gets on a plane and goes back to his own installation. The lieutenant is convicted and spends the next 7 or 8 years in prison until he was eventually paroled. Not exonerated, not acquitted at the appellate level, but paroled. because that defense attorney didn't do a couple of things. Number one, raise the issue, and if the judge had not let him call it, made an offer of proof as to why the testimony of the government's expert would have been important, that issue was not properly preserved from an evidentiary perspective. And it couldn't get over the hump of would it truly have made a difference. Was the error harmless or not harmless? Was there a constitutional right to present the evidence? And when you'd already had an expert testify for the court from both sides, the court said, hey, we don't know that it would really made a difference. Failure to raise the issue waived it under a 103 standard. It's just literally a classic example of the attempt by the rules to do what? To push the decision-making down to the level where it can best be made. And the people best empowered to make these decisions about the validity of an objection and the ruling on the objection are the trial lawyers and the trial judge. Because quite frankly, appellate judges are often not truly qualified to do it. They do it in an abstract fashion because they haven't been a trial attorney or a trial judge. Now, they're very smart people. The ones who have been trial judges are quite capable. It's why you get opinions like you've recently gotten from the Supreme Court, where Justice Roberts agrees with Sotomayor and Breyer. And Justice Kagan, the Harvard law professor who never actually practiced law, and was then the dean at Harvard, had a very different interpretation of a criminal procedure rule. And this all flows out of 103. The other thing that you need to remember is that once I've made an objection, I have no need to renew it as long as the court has ruled dispositively on the issue. But you have to have the dispositive ruling. And the judge saying, counsel will address that when the witness testifies, or I'm going to reserve ruling until you bring it up at the appropriate time, is not a dispositive ruling. And some judges do that to kick the can down the road to see if, in the context of the actual moment trial, you'll object or not. And the moment you choose not to object, you've just waived the issue. That's the way 103 works. It's on the shoulders of the attorney, not the judge. And it kind of has to be that way because attorney-client privilege allows you to know certain things. It's one of those places where the rules of evidence sort of interlock with our professional responsibility requirements. Yes?
And that's for if you want to take up the issue of appeal, right?
Yes. Because the whole idea behind 103 is to clarify the battlefield on the legal issues so that the appellate court can properly sort it out. And they're trying to balance the rights and responsibilities of counsel and the rights and responsibilities of the judge. Yes?
When do you move to strike versus making an objection? Is it after the statement has been made?
If the statement has been made, you have to move to strike. Because if you object and the objection is sustained, but the statement's already been made, it's already been taken into evidence. We all know the problem with that, though, is what? When you move to strike, the judge then instructs the jury to ignore what was just said, underlining the thing that was just said. And we're relying upon the validity of the judge's right under 104 to tell the jury what they can or cannot consider as a matter of law. And the problem is once the bell's been rung and the jury's actually heard it, it's problematic as to whether or not that's true. We've discussed that when we've talked about Federal Rule of Evidence 105, limiting instructions and whether or not they actually work, right? They work theoretically. They work for purposes of cleaning up the appellate record to remove appellate issues. But that doesn't mean they work practically from a persuasion perspective at trial. And I think the other example that I gave you guys on that, I'm not sure if I have or not, have I talked to you about the instruction on the right of the accused to remain silent? One of the instructions that most jurisdictions give, it's a procedural instruction. The judge will instruct the jury that in this particular trial, the accused has chosen to exercise their right to remain silent. They have not taken the stand, they have not provided evidence to affirmatively defend themselves, and they have that absolute constitutional right under the law, and you are to draw no adverse influence from the decision of the accused not to testify on their own behalf. It's called the right to remain silent instruction. What does it do? It highlights the fact that the defendant chose not to take the stand. It's designed to protect the constitutional right and say that there's not an inference, that a negative inference won't be taken from it. You're accepting that the jury's going to do that with it when you either ask for or agree to the right to remain silent instruction. I, as a defense attorney, would routinely waive that instruction with the consent of my counsel when my counsel did not testify. I would also routinely request that instruction when my client did testify, to highlight just what a big thing it was for the client to waive that right and take the stand. You had a question?
I was going to ask you, is it almost impossible not to have take something away from a defendant not testifying? The court member looking, seeing that they're sitting there, and it's all about them, and they just sit there and go.
Well, you know that the jury is going to want to hear the defendant's story. And you know that there are usually, given the way the character evidence rules work and the impeachment rules work, there are all sorts of reasons that your client may not want to testify. So this is really a huge issue in a criminal trial. So what are some of the ways that we might deal with that, knowing what we know now? Jury selection. One of the things we might choose to talk about during jury selection is how many of you believe in the right to remain silent. The way I used to do it was, what would be helpful to you to learn about in this case? Blah, blah, blah. Well, who would you want to hear from to learn that? Blah, blah, blah. Would you agree that all the folks who were involved in it might be folks that you'd want to hear from? Blah, blah, blah. Do you want to hear the story that the defendant has to tell? Blah, blah, blah. Why do you want to hear that story? Blah, blah, blah. What would you think if you didn't get to hear that story? And you'll get those answers that are about the right to remain silent, but you'll also get the admissions that I think he was hiding something or I'd wonder why. So one of the ways that we deal with this issue is in jury selection, because we're trying to deselect the ones who think if he doesn't testify he's hiding something. And we also want to find the ones who truly believe that you've got that right to remain silent. And what you're hoping for is to find somebody who had a friend or a family member who testified, told the truth, and went to prison anyway. And they say that during jury selection, because now we're beginning to educate in a way that can be helpful to us from a persuasion perspective. But this, you ought to see now, in a way that you did not when we began the semester, that 103, 104, and 105 are this dance of objections, ruling by the judge, and impact on the jury of hearing or not hearing a particular fact that has been sorted through the evidentiary law. And that probably wasn't completely clear when we first talked about these rules. Any questions about them now? Yes?
So, the substantial right will apply to both admitting and excluding evidence, right?
Yes, it does.
But the timely objection and specificity only speaks to admitting evidence, whereas offer of proof is what is sort of a highlight of excluding evidence.
Yeah, think about it this way. If you're trying to keep the evidence from being heard, you've got to give the objection before the evidence is heard, or you have to move to strike when it's been improperly heard. And so that fits with evidence that you're trying to exclude. On the other hand, when the judge has excluded the evidence, and you're the proponent of the evidence, you need the record to show effectively that the judge has got it wrong. And so the offer to proof is the vehicle that you use to have one more chance to sway the judge's mind and to make the record. And a very good offer of proof tells the judge, first of all, you know what you're talking about, you've thought this through, and gets the judge to begin to wonder whether or not you're going after the case on appeal. Are you inserting appellate time bombs into their record of trial through these offers of proof? And sufficient offers of proof become irritating to the judge, because an offer of proof at a certain level tells the judge, I don't think you got this right. And I think the judges who watch over you are going to agree with me. And therefore, I am going to make this offer. Offers of proof are a good place to insert case law that's on point too, right? And I have even gotten in an argument with the judge to the point where I've made an offer of proof with an accompanying statement of facts, with cases that were on point, and asked that that accompanying statement of facts and cases on point be marked as the next appellate exhibit in order and be placed into the record at this point so that it's clear. Because what am I saying to the judge? I think you're wrong, and I'm going to make certain that the appellate court knows how wrong I think you are. Now, I don't do that on an objection as to relevancy. I don't do that on a hearsay objection. But when it's something that shifts the trial in a way that I cannot recover from, and I have a good faith basis to believe that the judge has improperly admitted the evidence, I've got a duty to do this. There's a big issue right now in our plaintiffs' med mal world. We've just adopted Dalbert as the standard in the state of Florida. Fry had an exception that was called the expert's opinion exception, where the expert could just say, I think it's so because I think it's so. Dalbert does not allow for an I think it's so because I think it's so opinion. If I'm trying a plaintiff's case right now and I've got a hospital or a nursing home or someone else who wants their expert to just say, hey, I think it's so because I say it's so, and I'm an expert, I've got to fight like heck to keep that opinion out because it is arguably no longer admissible under the Dalbert standard. It's an open question of law right now. That would be a classic example of if I don't fight it properly on 103. And we're talking now the connection between 103 objections made at trial to motions in limine that are filed before and rulings by the court on those motions of limine. And you should see them now as a spear that arrows all the way in on a question of law that can in fact be case dispositive if the ruling goes one way or the other, almost to the point of potentially taking interlocutory appeals to the District Court of Appeals, although the court will often deny you the right to take an interlocutory appeal. But they don't like it when you ask for it. And if you really want to be difficult with a district judge, and I would recommend that you never ever do the following without first consulting with either the bar or your supervisory attorney. I'll give you an example. I have a client who wants to take the stand and testify. I know that the client is going to commit perjury if they take the stand, but they haven't committed perjury yet. I am not allowed to put perjury before the court, and if it comes before the court, I have to disclose under my ethical rules, right? So I try to withdraw from representation. The judge will not allow me to withdraw because the judge knows what's going on, and he wants me to either force the client to testify truthfully or force me to rat my client out after my client takes the stand, making me a witness, putting my license at issue, and calling into question my validity as a defense attorney. Not a knock on the judge, that's the judge's job to make me do that to get this resolved. So what do? I prepare a memorandum for record that outlines the perjury that my client intends to commit and the basis for why I think it's perjury, complete with addendums. I then have that memorandum for record notarized by my paralegal, and I put it in an envelope and seal it with a mark across the seal so that you can't open it without breaking the seal. And then when the judge does not allow me to withdraw, I say, I am handing the court reporter what's been marked as Defense Exhibit Alpha, or whatever it was, and Appellate Exhibit, the next one in order. And in that jurisdiction, Appellate Exhibits were Roman numerals, Prosecution Exhibits were numerals, and Defense Exhibits were letter. And I said, this exhibit is a sealed affidavit for the appellate court stating my reasons for attempting to withdraw. I cannot, under the rules of professional responsibility, disclose to the court at this time what is contained within that document. But I ask it be placed in the record so that it is available to the appellate court for their review if you do not allow me to withdraw from this case. Well, what do you think the judge did? What have I just done? I have placed an appellate time bomb in his court that I am trying to seal and protect from his eyes. He told me to get my toothbrush because I was going to jail. For what? Contempt of court. After he calmed down, what do you think he did? He let me withdraw from the case. What was I saying to the judge? Your Honor, this is how serious this is for me. I really have no other choice. Don't ever do that unless you've been practicing in the jurisdiction for a long period of time, and you know the court and you know the judge. The best practice is to never be placed in that position. But I had a crazy client, I had a crazy judge, and I had an unreasonable prosecutor. It was almost the trifecta of stupid. And so I had no choice but to try to find a way to continue to protect the rights of my client, even though it put me in personal jeopardy professionally with the court. And in the long run, it all worked out fine. Yes? I have been threatened but never held in contempt. And the reason for that is because, God, how can I say this without being arrogant on tape? I'm almost always right. And if you have a reputation of being right all the time, when you walk out on the limb on an issue, the court tends to believe you. And I also have a bit of the devil in me in that people like to laugh when I say things. I know how to push you all the way to the edge of being really pissed off and then saying the thing that makes you laugh, which has been of phenomenal use in my marital career. I'm just saying, 32 years and counting. If you can make her laugh, you're going to be okay. And if you can't, you're going to be in real trouble at some point, because you're a man. You're going to do something stupid. It's just guaranteed. I'm nowhere near as smart as my wife. I'm at work tonight, and she's on the couch watching TV, so it's not hard at all. And she works a lot harder than I do. She puts up with me. Let's look at preliminary ruling on questions, 104, right? You got to remember, what category is it in? Qualifications of a witness, existence of a privilege, admissibility of evidence. Those are the three things that it is the judge's responsibility under 104 to determine. The judge makes that call, not the jury. And when it's a judge-alone trial, the judge bifurcates their mind and addresses the legal issue, and then only considers the admissible facts when they ultimately make a determination in the case. And I actually believe that most judges do that. It goes a long way towards explaining some of their personality quirks, because they literally have to split themselves in two to do this sort of reasoning analysis. But these are the three things that the court is required to do. What's interesting is that the only evidentiary rule that impacts these determinations is privilege. It means the court cannot pierce privilege for the purpose of determining qualifications of a witness, existence of a privilege, or the admissibility of evidence. Court cannot do that. It can do anything else, to include considering otherwise inadmissible evidence. Hearsay evidence that will never be admitted. Character evidence that's never going to be considered. Prior conduct that's not going to come in. Convictions, the whole ball of wax, the court can consider. That's in the federal system. In Florida, the judge can only make considerations under 104 using evidence that is otherwise potentially admissible. So a Florida judge is more constrained on their ability to determine existence of a privilege, qualifications of a witness, or admissibility of evidence, in that they can only use evidence that is otherwise admissible to make those decisions. That's a limitation that we in Florida have placed upon our Florida judiciary. Arguably a smart limitation, because absolute power corrupts absolutely, regardless of the type of robe that you wear. 104B, this is what I think of as the conditional relevancy rule, right? I can connect up, I can show that a fact can come in now, and I can show that it exists later, right? That's just conditional relevancy. It allows for the economical movement of a trial in the fastest way possible, so that you can take witnesses out of order. Your Honor, I'll connect up, I'll establish the relevancy later, is a check that you can cash anytime you need to in court, as long as you have the credibility of being someone who the judge thinks knows what they're doing. If, on the other hand, you're new, or you've displayed a lack of capability in the past, the judge is not going to give you that degree of leeway under conditional relevancy. Why? because they're afraid that you're going to do something that's not then going to be repairable at the appellate level or at the trial level, right? So conditional relevancy is money that you put in the bank by displaying your character as a competent litigant. And that displaying your character as a competent litigant begins long before you make it to trial. It's all the stuff that you do in pretrial, all the ways in which you interact with the court before you ever get into the well of the courtroom. And particularly in the civil jurisdiction, particularly in the federal jurisdiction, with the changes that are coming, substantive changes to the Federal Rules of Civil Procedure regarding discovery, the judge is going to be more and more involved in the discovery process to include the oversight of depositions. And if you've shown the judge that you're not competent or capable, it's really going to hurt you in the long run. And the hearing of the stuff, cross-examination of the defendant. Just remember, when the defendant opens the door by testifying on a preliminary question, it's a narrow door, just to the issue, the constitutional law issue. If you're in my federal criminal procedure class next fall, we'll talk about this. I can put the defendant on the stand to testify solely on the issue of whether or not evidence should be excluded. And the cross-examination is limited to that issue. And oftentimes, if the exclusion is successful, you can't even refer to it during the trial itself. And of course, accepts out that weight and credibility, once evidence has been admitted, i.e., evidence of impeachment or bias, moving the needle towards the believability or less believability, is not constrained by the court, right? The rule does not limit your right to do that. That's expressly right there in Rule 104. And now we know from our study of the common law and from 608 to 609 how much sense that makes, right? Because once the jury's heard a fact, then whether or not that fact is more credible or less credible or should be given weight or not be given weight is a question that is non-collateral, and therefore you should be allowed to present evidence. And no ruling by the court under 104 should prevent that. That ought to tell you in a way, that ought to make concrete to you in a way that it maybe did not before, the power that is found behind Federal Rule of Evidence 104 and the power, the very real power of well-done impeachment at trial. I think it's sort of a neat connect between those 600s and the 104 rules. Any questions about 104 before I move on to 105? There being no questions, let's look at Rule 105. We've talked about this before. What do I want to point out to you? Timely request, restrict, proper scope, instruct the jury. So, on whose shoulders does the requirement for a limiting instruction rest? It rests on the shoulders of the party who is trying to exclude the evidence. So if I lose under 103, and the judge determines the evidence is admissible under 104, and it's admissible for one reason and not for another, let's say it's 404B, non-character theory of relevancy, I have to decide whether or not to request a limiting instruction from the court, making certain that my client is not treated as a propensity argument. One example. And I read 103 and I read 105 and it reminds me again, they're pushing down onto the shoulders of the trial attorneys the decision whether or not to request this evidentiary stuff from the court. Because that limiting instruction, we laugh about it a little bit here in class, sort of like gallows humor, right? That limiting instruction is actually not too terribly effective psychologically. At least that's the thought process. Although maybe juries actually do listen to it and write down all the things they're not supposed to consider. And then as they have their discussion, exempt out those things because they're on the list of things that aren't allowed. I think law students would do that. I think lawyers would do that because lawyers have been taught to do that. It's why you're not normal by the time you finish law school. We have removed your emotional reasoning and tried to replace it with intellectual, with logic reasoning. We've tried to push your ethos into a small minuscule corner of your life that's professional and expand your logos, to use the terms from Aristotle, right? The problem is that human beings are not designed to really work that way. So the efficacy of a limiting instruction in actuality, I have great degree of suspect for. But it is phenomenally useful in removing the potential appellate issue of the improper use of the evidence. Because the judge during jury selection goes through the jury the preliminary questions, including, do you all agree that you will consider the court the sole source of law? If I instruct you on the application of the law to the facts in this case, do you agree that you will follow my instructions as to the law? Once the jury members say yes on the record, it's presumed that they've told the truth and that they're going to do that. And that fiction allows for this fiction of 105 to work. Now, the reality of whether or not you ask for the limiting instruction, that's up to you in the moment, right? It's up to you in the moment. Sometimes I do, sometimes I don't, depending upon the case, depending upon my reading of the jury. If I feel like the judge has been unfair with me and the jury thinks the judge has been unfair with me, I might ask for that limiting instruction. And then once I get the limiting instruction, I might say, Your Honor, we ask that you lodge our continuing objection to the what we feel is the improper use of this evidence at trial. But for purposes of making the trial move along, we ask that that objection just be lodged as a continuing objection so I don't have to object over and over again. What am I really doing when I say that? I'm making an argument again that the judge has got it wrong. At 52 years of age, I can get away with that. 24, 25, you probably should not. Try that. Unless your boss tells you to. Or you bring in your boss with the gray hair and you have the boss do it. Because there's a certain dynamic there that can be painful. Hang on a second. Any questions about 105? Cool. Let's look at Rule 106. Although it does not say it here, it says, remainder of or related writings or recorded statements. This is routinely referred to in the literature as what? The rule of completeness. And the idea is that if one portion of a statement is admitted by one party, the opposing party should have the right, in order to place the statement in context, to admit the rest of the statement if they so desire. And it gives the power to the person who is the opposing party. Classic example. Cop is on the stand. They interviewed the defendant, but they never took a statement in writing. So you have the cop talking about what the defendant said to them. Okay? Now, maybe there's case notes, or there were other cops there too, and the defendant said some things that were inculpatory and some things that were exculpatory. When the cop testifies under admission by a party opponent about that interview, which part of that interview do you think he's going to talk about? The inculpatory statements, the things that make the defendant look guilty. That's admissible as what? Admission by a party opponent. Now, could the defense counsel ever ask the cop on direct about the statements made by the defendant? No, because there wouldn't be a hearsay exception that fits it. But the rule of completeness will let the defense counsel get in what is otherwise inadmissible hearsay in order to place the admissible hearsay statements in context. That's what 106 does. It ensures that you can't cherry pick portions of someone's statement to take it out of context. Where it becomes problematic is if I have a series of statements over an extended period of time. What's one statement and what's not one statement? Because what do cops often do? They'll bring in the defendant, they'll interview the defendant will tell a cockamamie story establishing how they're not guilty. They let the guy go, they do a little investigation, they bring him back in, and what do? They shoot down the elements of the story that were BS. And they might do this 3 or 4 times before the defendant finally confesses. At trial, which statement are they going to offer? The last statement that was a confession to the crime. Are they going to offer the defendant's earlier inculpatory statements? No, they're not. So should all of those statements be considered one statement under purposes of 106 because it's one long continuing interview taking place over a series of days, or are they separate statements? Knowing nothing else, how do you think most courts rule on that question? Separate. Why? Because it benefits the government. And that's exactly what they do. They treat them as separate statements. You'd really have to show some connection between the two. Now, that question is not universally answered in the affirmative in all jurisdictions. The Supreme Court has never spoken on it. And I think a crafty defense attorney can, with a straight face, make the argument that those interviews are really just one interview that was conducted over a series of days on purpose for psychological purposes by the cops. I've had some small success doing that and getting in things that my client had said in an earlier interview. If not, for the truth of the matter asserted therein, to attack the credibility of the investigation of the cop because he didn't go look into what my client asked him to go look into. So for its effect on the listener, to explain what he did or didn't do in the shoddiness of the investigation. What are we seeing here? I'm talking about a connection between 106, 801, and theory of the case. Just something to point out. But remember, for the federal rules, get you in just a second. From the federal rules purposes, 106 applies to both written and statements recorded by any other means. It was originally drafted to just be writing. The rule in Florida began with just for corporations, but has been expanded by case law to be applied in an almost identical fashion to the federal rule, so that it's also applied to individuals and not just corporations. Question?
If you have a statement that is in one sitting, so it's clear that it's not several different interviews, but it covers several different distinct topics, if someone introduces evidence from one topic, clearly you can get the rest of that interview on that topic in. Can you also get something that's completely irrelevant to what the other party brought in?
If it's completely irrelevant and I'm the judge, I'm going to say that the rule of completeness does not cover it, because you're now trying to offer up evidence on a new issue, and I would make you try to adopt the witness and offer it, and I would probably sustain a hearsay objection at that point. But if you set it up the right way, from your questioning technique perspective, if you also wrap those other issues around questions of bias, motive to lie, improper investigation, you might be able to slide all that stuff in under a theory of impeachment, even though it's not admissible substantively. I, as the court, know that your questions are logical and that your questions go to impeachment. That jury listening may very well treat it as substantive evidence, particularly if the other side doesn't object and try to shut you down, and at the very minute at a minimum, get a limiting instruction from the court saying, hey, Your Honor, the jury needs to be instructed that they can only address these other statements as it pertains to credibility of witnesses and not substantively. Because otherwise the jury's just going to hear that it was said. So there's a way to do it, but I can't actually argue it in that fashion. You follow me? So I can win the realistic battle in the minds of the jury as to whether or not they've heard it, and then fashion my arguments so that it acknowledges it in the appropriate way from an impeachment perspective. But the entire time while I'm saying don't look at that man, don't use it for that purpose, I'm actually saying at a certain level, use it for that purpose. That's why the concept of jury nullification still exists within the United States, because we let the jury make a lot of those decisions. Defense attorneys love jury nullification. Prosecutors think it's anathema to the justice system. The judges, by and large, view it as a challenge to their authority, because jury nullification almost requires the jury to take the bit in their teeth and ignore the instructions of the judge on the law. And yet it routinely happens. You could argue that the O.J. Simpson case was jury nullification, that it was nullification and a repudiation of the law enforcement tactics of the LA police for an extended period of time in that part of the world. And they didn't really care whether or not O.J. Simpson was guilty. They were not going to hold him accountable because they were given a colorable reason. And if you look at the O.J. Simpson case, you remember they made it all about the racial bias of one of the lead detectives in the case, Mark Furman. It was admissible as to Furman lying under oath about whether or not he'd ever used the N-word, and it also went to Furman's bias against O.J. Simpson in the fact that he was involved in the investigation of the case and the alleged adulteration of some evidence. The jury used that to decide to completely dismiss anything that Mark Furman touched from an evidentiary perspective, which made it very easy for them to acquit O.J. Simpson in a relatively small period of time, despite some somewhat overwhelming evidence that he actually committed the crime. Now, is that justice? Was that just us? I don't know. But it's a really interesting example of this interplay between facts that are admissible for one reason and not admissible for another reason. Kind of cool. Any other questions about 106? No? Okay, just touching the eyeglasses. I'm trying to read everybody's body language, and there are a lot of you. I can't tell if you're grateful that I'm going over it or suddenly terrified by the fact of all that you've learned this semester and going, oh crap, right? Okay. Let's look at 201. Judicial notice of adjudicated facts. You need to remember and treat 201 as a sorting hat kind of game, like the sorting hat in Harry Potter. Identify the fact, figure out which house it does or does not belong in. And if it belongs in one of the houses that are identified in the rule, then the court can take notice of it. And then you need to remember how the court takes notice. They can do it on their own. They have to do it if a party requests it and lays the prima facie case that the judicial fact does, in fact, exist. And they can do it at any time. Instructing the jury. This is a point that comes up quite often on bar exam questions. If we look at it, in a civil case, must instruct the jury, must, to accept the notice fact. In a criminal case, may or may not accept the notice fact as conclusive. Why? Because judicial notice removes from the party for whom the notice is taken the need to prove that element of the cause of action. If a judge takes judicial notice of a fact that's dispositive on an element on a civil cause of action, everybody has to agree to it in a civil case. But that pesky constitutional right, the requirement that the government prove each and every element of the claim in a criminal case to a beyond a reasonable doubt standard, means that judicial notice in a criminal case does not bind the jury. And the jury is free to not accept the fact for which the court has taken notice. This is a classic example of the constitutional underpinnings of evidentiary law. And it's really that and which categories judicial notice fall into that you need to remember for purposes of the short term and the long term as you go out and practice. Judicial notice can be a very effective tool to shut down cases in certain areas. Like, think of the Hartwell case file. Judicial notice of when the sun went down on the 21st of March might be helpful, if that chart in there is correct. So let's look at, that's 201. Let's look at 301. Presumptions in civil cases. Couple things to remember. Presumptions, Rule 301, is just a logical construct. I get your question. You got a question? We'll come back to it.
Actually, 201, but
No, go ahead then. What's the 201 question?
I just wanted to make sure I understand. Judicial notice is basically the court telling the jury, these are the facts.
Or this fact is true.
This fact, okay.
And it can't be a legislative fact, it has to be an adjudicative fact.
Got it.
This fact is true, and you must accept it as being true. The time the sun went up, the time the sun came down, when the plane took off from the airport, the existence of a statute or a regulation. These sorts of things the court takes judicial notice of when they're properly proven. You got a right to object. You have a right to be heard on whether or not it's a contested fact as opposed to an uncontested fact. But if it's uncontested and it falls into one of those categories, the judge of their own volition can do it, or at the request of a party can do it. It's a very good tool in a civil case to remove the uncontroverted issues from the trial. It doesn't work in a criminal case. And if you apply it in a criminal case, you actually create constitutional error. Yes?
Is it the same as a stipulated fact?
No, a stipulated fact is different. A judicial notice fact comes from the court saying this is so. A stipulated fact comes from the parties saying that we agree that this is true and we agree to be bound by it. So, for example, the language on the stipulation of fact often reads as follows. It is hereby agreed between the parties that the following fact is true and admissible. And then the fact is given. Now, if it's a criminal case, it is hereby agreed by and between the parties with the express consent of the accused that the following fact is true and admissible. And if the form is done properly, it has the signature of the prosecutor, the signature of the defense counsel, and the signature of the defendant. And the judge goes over the impact with the defendant of a stipulation of fact before allowing that fact to be accepted by the court. Now, you can withdraw from stipulations of fact up until such time as they're admitted at trial. What does a stipulation of fact do? It gives you a quid pro quo. You usually get something for giving something. I used to routinely give stipulations of expected testimony, and occasionally stipulations of fact as a prosecutor when it would save me the money of bringing a witness. You know, particularly when I was in Germany, I'd give out stipulations of expected testimony like candy. Write them up. Talking about how wonderful your guy was before he raped this girl. Great. Not a problem. Sign them off, read them into the jury, and then I would tell the jury why it didn't matter. Stipulations of fact, though, have more power because they bind us factually. In your 4-hour trial problems that you've got for your trial ad classes, your finals, there are certain facts that you're bound by stipulations of fact. Much like we talked about the other night, don't try to run away from them. Figure out how to use them for your benefit. Because they're a two-edged sword. They always cut both ways. You just got to sort out the theory of the case that's going to help you. Stipulations of expected testimony are different. And stipulations that are not factual in nature, but that are evidentiary in nature, that can be read at various moments to the jury, those are stipulations. So if I've got a stipulation that's in my fact pattern, or a stipulation that's agreed between the parties, and I'm going to publish that stipulation to the jury as part of my case in chief. Your Honor, at this time, the government wished to publish stipulation number 12 to the jury. We wish to publish it by reading it aloud. All right, counsel, you may proceed. How do I begin that stipulation? It is hereby agreed between the parties with the express consent of the accused that the following facts are admissible and true. Bop, 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 bop. Why am I doing that? Because I'm underlining for the jury that we all agree that this is so. It's a fact that helps my case, and I'm going to make certain that that's properly identified. It's properly identified. So we went a little bit afield there talking about stipulations of fact and stipulation of expected testimony, but they are related to the concept of judicial notice. The other one that is problematic for law students and problematic for attorneys who don't actually practice law is presumptions in civil cases. What this really is a logic tree rule. Basically, it's saying that if one side presents some evidence that creates a presumption that a fact is true, then the other side now has the duty to present evidence to rebut it. And if they don't present evidence that rebuts this fact for which a presumption has been created, then the judge will instruct that the jury should presume that that fact has been proven and remove it from the purview of the jury for deliberations. This is a civil case, not a criminal case. Presumptions don't work in criminal cases. And an instruction on a presumption that removes the burden of proof as to an element of an offense in a criminal case is going to be constitutionally invalid. And there's actually Supreme Court jurisprudence on that particular issue. Now, because there's Supreme Court jurisprudence on an instruction by presumptions given by a judge in a criminal court using the civil rule, and there's actually a Supreme Court case, and because presumptions require you to be able to look at procedurally what actually happens at trial, presumption questions seem to routinely show up on the bar exam. And yet, when I look at the rule, it's nothing more than an explanation of logical thought process. If I present some evidence that makes you guys think a fact is so, and the other side never rebuts it, then we can presume for purposes of these proceedings that that fact is true. Once evidence is offered to rebut the presumption, it's now become a contested question for the jury. How can I offer evidence to rebut a presumption? Through the cross-examination of the witness on that presumption? Or through the offering of other evidence that goes the other way? Why is this sort of hard to really apply? Because presumptions don't exist in a vacuum. Trials don't occur that cleanly. And it's often not clear what presumptions have or have not been raised or have not been rebutted. Now, if I'm a good civil trial lawyer and I think I've raised a presumption and it's never been rebutted by the opposing side during their case in chief, I'm going to ask for an instruction on that particular fact from the court at the close of the trial. So when we go with the judge and we have our outside of the jury's hearing conference on what instructions I want, that's when I strike asking for presumptive instructions on these elements of my cause of action because they've never been rebutted. Even though the other side may not have allowed me or may not have admitted to it in interrogatories or responses or in depositions. So they contested it at trial structurally, but they never actually contested it at trial substantively. And I watch for that and I find it, and then I ask for those presumptive instructions in the civil case. That can clear the thought process of the jury up remarkably. If I'm the plaintiff in a civil case, what do I want? I want the jury focused on the one thing that matters. I don't want them going through it on multiple occasions. Yes?
Can you ask for this instruction only on elements of cause of action, or can it be on anything that hasn't been rebutted?
Anything that required, that was a fact that was potentially in controversy, but usually those facts that are in controversy, if they're not part of the cause of action, it's really not case dispositive, and the judge is not going to give a presumption instruction on those issues. But the judge is going to talk about presumptions in their instructions to the court when they're raised. So I keep track, and if I've got one where I presented all the evidence and no one's rebutted it, I'm going to ask for that instruction to the jury. Because I didn't get to argue what that means. Members of the jury, the judge has told you that the following fact is presumed true because they never presented any evidence to rebut it. That means that the only evidence you have is the evidence that supports my side of the case. Why is that? It's not because they're incompetent. We've seen opposing counsel, they're phenomenal lawyers. It's because it just ain't so. Which means that you can consider this evidence in the light most favorable to my client. So presumptions have phenomenal cosmic power within the civil arena. They do not within the criminal arena. Yes, ma'am?
Does that go towards, like, expert opinions that go directly towards an issue too? Because wouldn't that put a burden? You have to bring an expert for every, tip of the cap for every expert.
You don't. Experts are treated separately from presumptions. Presumptions deal with facts in the case. Not expert. An expert opinion is just that. an opinion, right? It's an interpretation of issues within the case, but it's not the issue within the case itself. So you want to treat those in different categories. All right, folks, tonight I've talked about 101, 102, 103, 104, 105, 106, 201, and 301. I hope that as we talked about them, light bulbs went off that did not go off the last time we talked about these subjects. In class on Wednesday and Thursday, I'm going to do 401, 402, 403, and 404. I doubt seriously that in the next two class periods we'll get past 404A and 404B. My guess is we'll get through 404A and we'll probably begin 404B next week. But for your reading pleasure, I would suggest that you go back and look at 401, 2, 3, 4, and maybe even start looking at 5 and 6 again. 5 for sure, because it connects to 404 heavily as to structure of materials. All right? See you guys on Wednesday.